That's why I have a jackhammer.
It's really like a push off. But then it has steel-toe boots on it for the hammer.
He didn't. And that's another defense is.
He wasn't prepared. Why jackhammer?
Yeah. Wear what you're supposed to wear.
So want to get started?
Sure.
Then we can leave earlier.
Yeah, exactly. I have no complaints against that.
Yeah, I like your style.
I have stuff to do. You guys have stuff to do. Sure, right?
Yeah.
And death is always a fun topic.
Always.
So last week you went over some of the basics, introduction, what's, what is estate planning, what's a will, all that fun stuff. So today the sort of goal of today is figuring out what does intestacy mean. When I say the word intestacy, what are you thinking about? And what does that mean under statutes, and what does that mean under who's going to get what?
So like they die intestate, doesn't that mean that they died without a will?
Right. Now, what's the ramifications of that?
It goes to the next of kin.
Exactly. So we're going to figure out who exactly is the next of kin under what scenario. Yeah, well, spouse, if you don't have a spouse, if you have kids, if you don't have kids, etc., and whatever the word escheat means, what does that mean?
Goes to the state.
Exactly.
What is that?
And that, how often does it happen?
Probably a lot.
Probably a lot.
You think so?
Rarely happens.
Very rarely.
Really?
Because you can see in the materials, we're going to go. We're going to go to long lost cousins. We're going to find somebody in the woods of Tennessee before we get anything to the state of California. Okay. So let's just go through the chapters here. So it's important to remember, although we have the Uniform Probate Code in our reading materials, we don't have that in California. We have the California Probate Code. So when you're looking at things and you're getting ready to study for the bar exam, you're going to be using the California Probate Code and the statutes in the California Probate Code. Okay? So for instance, if we're talking about intestacy, you're going to go to sections like 240 in the Probate Code. And that's going to tell us what does that mean, intestacy, under California Probate Law, okay? All right, so if we have a surviving spouse, what is that surviving spouse's share going to be?
Whatever the prenup.
Not a divorce.
Oh, that's true.
It doesn't depend though, because I remember reading in the book that there were some circumstances where the wife would get 50% and then the rest would go to the kids. But I guess if they die intestate and there's no will directing it, then the surviving spouse should, in theory, get everything.
Well, it depends on one thing. What type of property are we talking about?
Oh.
Are we talking about community property, or are we talking about separate property? So remember, in California, we're a community property state. So if I die and I don't have a will and I'm intestate, so it's going to be by the laws of intestacy, and I have a house that's community property, it's going to go 100% to my spouse. That's community property. If I have separate property, where's it going to go? Let's say I have a husband and one child. Where do we think it's going to go? Now, this didn't specifically tell you in the book. I'm just helping you to think about it, and I'm going to give you some code sections in the California Probate Code about where you can look for this.
You have separate property?
I have separate property. I have one husband and one kid.
And does it say where you have a will or a trust that specifies?
It's intestate. I just, boom, got hit on 111.
He's still her heir, though. The spouse is still the heir.
Sure.
So I think it would still go 100% to the surviving spouse, unless otherwise, right?
No.
Or is that the 50-50 split?
It's going to be 50-50 under that scenario. And where you're going to look for that is you're going to look in Probate Code 6401, 6402. So 6401 is when I have a spouse and I die with property. And 6401, Probate Code 6401 says 100% of my community property is going to go to my spouse. 6401 also says, later in that section, if I have separate property and I have one child, my spouse and my child get to share it. Now, what happens if I have 2 children?
Then it would go 50% to your spouse and then 25 and 25?
No.
Oh.
My spouse gets shafted. My spouse gets 1/3, and my children get 2/3.
I'll split evenly amongst all the parties you have.
Yeah. And the more you go down the line, so we favor the children over the spouse for separate property. Okay? So that's something that's probably not intuitive, right? Because we all said, well, yeah, why doesn't the spouse just get everything? That's not the case. So when you have a bar question, because again, that's the end goal, right? When you have a bar question, the bar question says something like, husband inherited Blackacre through inheritance. It's his sole and separate property. He died. Where does Blackacre go if he has 2 children and a spouse? That's when you got to think to yourself, okay, this is probate code 6401. And I got to remember who's getting what. My spouse is only going to inherit a portion. My children are going to inherit the other portion. Right? So that's what's important under that scenario. Now let's say we don't have a spouse and we just have children, or we don't have children. That's going to be 6402. So that's also going to be in your bar question if you get a wills of trust question. You know, Joe dies, Joe owns Blackacre, doesn't matter if it's community property or separate property, it's all going to be separate property because he doesn't have a spouse, right? He's got 1 kid and 1 kid that died who had kids. Where's it going to go? And that's when you got to think about, okay, well, who's in the line of descendants here? Who's in the line of heirs? Okay, so make sure when you're looking through intestacy, I want you to think about those couple of sections. 240 is, sort of intestacy as a general scheme, and 6401, 6402 are the specific code sections under the California Probate Code that gives us the roadmap of where it's going. Okay, and it's going to go really down the line. So, like we said, first people who are going to get it are going to be your children. The second people who are going to get it are
Their children.
Well,
Or your parents.
your parents. Yep. Then you're going to have issue of parents. Now, what does that mean? That's a really antiquated way to say
Your brothers and sisters.
siblings. Yes. So issue of parents. That's what the bar is going to do. It's going to have these weird ways of saying things. Well, why don't they just say siblings? They don't. So it's going to say issue of parents. And what's an issue of grandparent?
An uncle.
Exactly, right? So we're going to continue to go down the line. And then it's going to go to something that says next of kin. Well, who the heck is that? It's basically anybody you can find in that lineage, right? And the closer degree, the more they're going to get. So if I have a second cousin and I have a third cousin, my second cousin is going to get, my third cousin isn't, right? That makes sense, right? To a certain degree, that kind of makes a little bit more sense than, the husband question. Okay. So you read in here too about same-sex marriages. Obviously, this is really antiquated, and it's antiquated. Why? Because in 2015,
the book's a little old on that.
Yeah, there's actually a brand new book. It just came out immediately before this sort of syllabus went to print. And so next year, not that you're ever going to repeat this class, but next year we'll have a new book. And so that's important too. So now remember that if you have a question on your state bar exam that says husband and husband are married, who inherits? If it's community property, it's going to be husband, 100% of the husband. Okay, it's not going to matter if they're married here. It's not going to matter if they're married in Nevada and then came and lived in California. Because of that 2015 case by the Supreme Court, you can't deny same-sex marriage in any jurisdiction. Okay, so remember that that's going to be important. We've talked a lot about it in here, and it's not that applicable because again, it's an old case that they're talking about. We have a new case in 2015. Okay. So now what are we talking about with respect to simultaneous deaths? So this is going to come up too because bar examiners like to screw with you. And they're going to say, we have a simultaneous death, now what happens?
It depends on who died first. If you can determine who died first.
Mm-hmm.
And then there was some rule about they have to survive by so many, is 120 hours by clear and convincing evidence?
Mm-hmm. So that's the same rule in California. And that code section is 6211. And then we're talking about intestacy again. So now that we're on that subject, who wants to take Janice? Did we all do case briefs, by the way? Ish?
Yes. Okay.
75.
Oh, yeah, just the two moms.
Tylenol case.
Yeah. All right, so husband and wife ingested bad Tylenol and got cyanide poisoning. The husband died essentially at the scene, and the wife went like comatose. She had some delta waves, and she had some reaction in one eye.
Mm-hmm.
She was, I think, 2 days in the ICU, and then she finally died. Although they had to get her heart restarted in at the hospital, she maintained her own rhythms. And then the two moms sued each other over husband's life insurance policy. The insurance company thought
What
that
did
she
the
had
life insurance
survived.
policy say?
It was $100,000.
Who was the first beneficiary? Wife, yeah. And then who was the second beneficiary?
Well, it would have been his mom, I guess, as a second. Sure.
Yep.
Sure. So they brought doctors forward and the nurses at the hospital, and they decided there was sufficient evidence that she had survived him. The rule I got here is that survivorship is a fact that must be proved by proponents of the evidence by the party whose claim depends on survivorship. And yeah. So in the end, they decided that they affirmed the decision and decided that she likely, or that they didn't find enough evidence to overturn the decision that the trial court found.
So who got the life insurance?
The wife's mother.
Because it was the wife's estate.
Correct.
Mm-hmm. So what's inherently wrong with this decision? What do you think?
Well, I just picture the wife's ICU bills and just think that, like, I think they should be paid off by that $100,000. Like, that's, so I think the mother should get it because she's probably the one stuck. I mean, that's how I think. But yeah, it's sad that these two, I think it's sad that these two people are just fighting over life insurance proceeds when there's probably a big medical bill sitting out there.
Okay.
To me, that, I don't
let go of that because that happens all the time.
I know. I'm not good at. It's fine with me. I don't really care either way, I guess.
What about you, Vincent? What do you think is inherently wrong with this one?
Inherently wrong with this one?
Or what are some potential problems? What do you see as a
They both were
potential
technically
future?
dead at the same time.
Right.
I mean,
And what is that? We're depending upon whom to make that decision.
Doctors.
the court.
Doctors.
Well, yeah.
Right? So if a doctor walked in at 2 p.m. and happened to detect some flicker, which may not have even existed, she stays alive. He comes back now 4 hours later, and there's a new doctor, right? And her chart may indicate some flicker of something. Now, what if instead of them declaring husband dead immediately, that same doctor had detected a flicker and they kept him alive? Right? So it's inherently problematic that we're dealing with a succession problem that's 100% based on medical diagnosis. That can be problematic. Because also, if wife's on a ventilator, I might just keep her there for 120 hours. Right? That may be a moral dilemma as well. Is that appropriate action or not? Is she, by clear and convincing evidence, still alive? And what does that mean? If there's no actual rubric as to there has to be brainwave, there has to be some sort of response, there has to be this, there has to be that. Technically, you're still alive, even if you're on life-sustaining treatments. If you're on a ventilator, if you're on a nutrition and feeding tube, you're technically still alive. So that's some problems with this type of a case. And if you see this, that's what you're gonna be thinking about. Okay, well, who's still on? Who's alive? Who's not alive? When did you get determined to be dead? When weren't you dead? Who determined that? Those are all questions that are gonna be red flags in your brain as to, okay, what do I need to think about here? And what you need to think about is the survivorship clause, first and foremost. And you might throw in a public policy argument, which is, well, even if this person was alive, public policy would warrant that this person be deemed as predeceased because they didn't really survive, right? It's not as clear as, okay, husband died 10 years later. Great, that's easy, right? You're not gonna get bar questions out of this, right? And so let's compare that to California Probate Code. We have a California Probate Code 220, and that is our code which says that it is clear and convincing evidence that you have to survive. And if you don't, how is property treated? So under this scenario in Janus, if they had been deemed to not have had clear and convincing evidence for the wife, who would have gotten what? So husband owned the life insurance policy. Who would have gotten the life insurance policy?
His mom.
His mom. Because, as we know in California Probate Code 220, if you can't determine by clear and convincing evidence, husband's property is going to be deemed as though he is the survivor. Wife's property would be deemed that she is the survivor. So the technical result of Janus would have been husband's life insurance policy would have still been his because he survived his wife and he died after she did. So we call that post-deceased. So he would have post-deceased his wife, which means his contingent beneficiary would have received the proceeds. And under Janus, his contingent beneficiary was his mother.
So if you die simultaneously,
And you can't confirm it by clear and convincing, yeah.
the beneficiary is deemed to have predeceased the insurance policy holder, correct?
Correct.
And then it would go to whoever the insurance policies, either descendants are, or if they had a contingent beneficiary, then it would go to them?
Yep. So if we didn't have a contingent beneficiary, it would have been the husband's estate. Now, that would have then gone to his wife, presumably, in some form, whether it be separate property or community property. But that's what it's treated as. So if you cannot determine by clear and convincing evidence who dies first, your property is yours, his property is his, and the person who owns the property is deemed the survivor.
And is that only for life insurance? So like,
No.
say you don't have a policy and say you have the house and you guys die simultaneously, how does it determine who predeceased who as far as separating the...
His heirs, her heirs.
And is they just split the estate 50-50? Okay.
Because they each had a 50% interest under that scenario.
Okay.
Okay. Did anybody have any other questions about Janus?
When you're looking at advanced healthcare directives with the spouse, you should plus account for that surviving of 120 hours.
Yeah, so if you have that in there, but then again, now that becomes a public policy question. Are you on life-sustaining treatment just to survive for 5 days? Or are you really on life-sustaining treatment because there's a hope that you'll come out of it, right? I think the goal here is to just document the file. And if the practice, what's it called, the other portion of the exam where you have to pretend to be an actual lawyer.
Oh, the performance exam?
Yeah, so if you do that in the performance part, what are you gonna do as best practices? You're gonna make sure your medical records are documented exceptionally well. Have them treated, have them reviewed on a continual basis to make sure that they're not just tangentially alive, they're really actually alive and they're supposed to be for the purposes of surviving. Okay, so what about that fun one where the husband and wife, husband dies and on the way to the funeral, wife is killed by husband's coffin? That was one of those little fun hypotheticals.
Oh yeah, but see, the way that I read it, and I probably read it wrong, but it had to be from the same occurrence, didn't it? Or does the surviving spouse just have to survive by 5 days? So even if they die within a day of each other, if it's a completely different occurrence, it's still determined to predecease? That's BS.
So yeah, under this rule, so if this is the case, right, under the 120-hour rule, husband is deemed to have survived wife when husband distributes, or when husband's estate gets distributed, because wife didn't survive by 120 days. She was survived by 1 day. Even if she was dead, she was killed because of completely separate, independent action. She didn't survive that 5 days.
That's what we chatted.
Okay, so let's go to some fun things. So we've all heard of Aretha Franklin.
Mhm.
So do we know how her estate's gonna go?
She had no will.
Yeah, she didn't. So how's it gonna get split?
Kids.
Because I don't think she had a husband.
She didn't have a husband. Well, she had one before, but she didn't have one when she died.
So then we go to the kids, unless one of the kids are dead, and then we go to the kids.
Alright, so let's put her on the board. So Aretha Franklin's here. Okay, and she has 4 kids. One's by the name of Clarence, one's by the name of Edward, one by the name of Teddy, and one has this very interesting name of Teacalf, or Keycalf. So under intestacy laws, if we have a per stirpes, who gets what?
25.
They do. And that's going to be the same if it's per capita with right of representation, or if it's per stirpes. Okay? All right, now let's kill off a couple. Let's say Clarence is dead, and he has 1 child, a daughter. And let's say Ted is dead, and he has a daughter and a son. Now who gets what?
Per surface? 25, 12.5, 12.5, 25, and I'm going backwards. So
So
Wait, what?
25, 12.5, 12.5, and then 25.
So this is a quarter.
Yeah,
This is a quarter. This is an eighth.
Eighth.
This is an eighth, and this is a quarter.
Right.
Everybody thinks that?
Well, it's because they get the 25%, they get the 25%, they get 25%, and then T's 25% is split in half between the 2.
Mhm.
I don't know what those are, some percentages. That's one from law school. But yeah, that's how it's right.
Does that mean everyone else gets a quarter except those 2 that get half a quarter?
Yeah.
They split the quarter.
That's true. Okay. Now let's make it a little bit more interesting. Now, what is it per stirpes on this one?
25, 12, 12, 12.
No, it's more,
It's-
it's a third now.
What is it?
So it turns into a third, and a third,
Oh,
and then the third.
Third and ninth and ninth and ninth.
There it is.
Yeah, I don't know what the rest.
Yeah.
Okay, so we're
There's
gonna
a third by 3, a third by 2.
Oh, they're dead, not anybody.
Yeah, they're dead by
Yeah.
I didn't see that.
Keycap is gone and he didn't have any kids. Probably because his name sucked. I mean, Keycap. But anyways, okay, so we have a third for Clarence's kid, and we have a ninth each for all of Edward's sons. And then Teddy has a daughter and a son, and they each have a sixth, right?
Yeah.
Okay. Now, if we had it per capita with right of representation.
wouldn't it still technically be the same because they are all at the same generational level?
Is that true or not?
I got confused by all those different things.
But remember, if it's if they're all at the same level, they all get the same thing. So if they're all getting the same thing, what do they get under per capita? With right of representation.
They all get a 6.
That's right. So it's very, very different. Right? So now you get a 6. Oops.
Oh, okay.
So this guy's getting a 6. This guy's getting a 6. This guy's getting a 6.
What's the difference with per capita and revenue?
They're stirpies.
Restricted.
So per capita with right of representation is supposed to be more fair. But fair to whom? Right? It's only fair if you include this entire group of grandchildren, right? Because these are all the grandchildren of Aretha. If you're including the entire group of grandchildren of Aretha, then you think it's fair. Because you're all in one class gift, right? But if you're Clarence's son, or daughter rather, you're not happy with that. You're getting a lot less. You're getting half of what you would have gotten if it was under a different scenario. So it's really important. I know these are antiquated terms, but it's really important that we make sure we understand what per capita is with right of representation, and what does it mean when we say per stirpies. Any questions on that one?
What determines between our per capita per stirpies? Is that the state or is that?
Yeah, it has to say it. So when you're writing your will or a trust, or if you have your bar question, it's going to say it for you. Because if it doesn't say it, there's no way for you to guess. Let's just do a couple more so we're clear on it. Okay, first stirpies, what do we have?
25,
25.
Yep. Okay. And if we have per capita with right representation?
Then it would be 25 to 25, and then the 50 would get split a quarter between the two kids, right?
So it's the same result.
Oh.
Right, it's the same result because these people still live. This line of descendants still lived. So that's what you want to make sure you're going down is who's alive? Who's the first generation that's alive? Well, her first generation are her children in this scenario. Right.
But in a per capita one, say son dies under E and son has a son and a daughter too. So it goes down one more level for one of the sons. Then it would still only be 25 to 25. The 50 would then get split a third, and a third between the remaining son and then the two daughters, right? And the surviving children of the deceased son wouldn't get anything.
The surviving children of this guy?
Yeah.
No, they still would get something.
Even under the per capita one?
Mm-hmm. Everybody still gets it if you survive. We don't disinherit people. We go to the living generation. So if this person had died and it didn't have kids?
Yeah. Oh yeah.
That's true. But if this person has kids, this person gets included. We always go down until there's no more living people. Okay, so we're not going to disinherit this daughter, which is going to be a great-granddaughter under this scenario. Okay, so important to remember that we're going to always go down until we have somebody who's alive. Okay, if it stops, it's okay, and they don't get it, right? So nobody on Clarence's side would get it. That his portion would be reallocated to everybody else that's alive.
But in, so let's say that a D under T has a child as well.
Mhm.
I understand why the first D on the left inherits because their parent has deceased.
Mhm.
But does the other one also inherit?
So this person down here,
Yes, but D's still alive.
because this person, this line's alive.
Okay,
We stop when they're alive.
okay.
So this great grandchild doesn't get anything because her mother survived her. Okay. Okay. Oh, this is a fun one. What about double inheritance? Do we know what double inheritance is?
Parents inheritance, leave something?
So double inheritance is when you're adopted out
Oh,
and you want to inherit it from your biological family and you also want to inherit from your adopted family.
well, that's Hall versus Bellingham.
Mm-hmm.
It says you can't really do that. Once you're adopted, you sever the line. And
So why don't you brief that one for us?
Yeah, so I kind of like this case.
Good.
Pretty much, you have, let's see, I remember it's been a while since I heard it, but it was, okay, so there was a child that was adopted from this gentleman. His name was, Earl. Okay, so someone adopted Earl's child, but then 25 years later,
Well,
Earl's
who adopted Earl's child?
it was,
Just some random person
no,
or?
it was a Kelly or Earl's. I think it was just, it was
Wasn't it the spouse of Earl's wife?
spouse of Earl's wife, the new father?
Yep.
Oh, yeah, so the spouse of Earl's wife, okay.
So stepdad.
Stepdad, so he was kind of disconnected from that lineage because it was adopted by his stepdad.
Mhm.
Then Earl's brother later dies 25 years later. And now we have this kid trying to inherit from his uncle.
Yeah.
But the rules say that once you adopt a child, that child becomes as if he was your born, once you declared he was yours. It's like he was born from you, he inherits from you, he has all the rights your other natural birth children would have.
Mm-hmm.
And yeah, he's trying to collect from the inheritance, but it says no, as soon as you were declared adopted, you lost all rights to that inheritance, and now you're on this side of the family. Drawn there.
So this kid's not getting anything from biological uncle's estate.
No, and then like the last time it says the legislature give it and the legislature take it away.
Mm-hmm.
So I took away in this case.
Mm-hmm. Okay. Do I have any inherent problems with this one?
Well, I mean, yeah, what if they don't find any biological, like other people that are related to this guy, that's gonna have to go to the state or something, right?
Maybe. Anybody else? What about you, Vincent? Any inherent problems with this one?
Not really, no. Remember. Not that I remember.
Okay, that's okay. You might think, oh, that's fine, it works for me.
There's no rights anymore. Oh, well, the kid didn't, what if the kid didn't? No, well, can't leave it up to the kid whether he's adopted or not, I guess. I'm not sure.
Getting closer. What about you, Will?
I mean, I'm not sure what would happen under certain scenarios. Like, what if, what if somebody is like I don't know, like a wife and an adopted, or, I mean.
Yeah, we'll get to that fun one too.
That happens, but it's, I don't know.
But what about this? I mean, they were only adopted because their dad died, right?
Yeah.
It's not like they were given up. It's not like they didn't have any more relationship. It's because dad didn't exist anymore. And now mom has a new husband, and husband wants to take the kids traveling. Okay, well, the husband can't do that legally without some sort of parental right, right? And so that's why they got adopted, because new stepdad is the only dad they have. So yeah, the court says, no, you can't do it, case is closed, you can't double inherit.
But is there a scenario in which that child would still get something from the deceased parent?
Well, yeah, in
Yes.
2008 they amended it.
So let's go to probate code section 6451. So there's a very small percentage of the population where this will come into play.
6851, you said?
6451. And this is what that one's about. So an adoption severs the relationship of parent and child between an adopted person and a natural parent, and thus the adopted person does not inherit from her natural parent unless, two conditions. First condition, the natural parent and the adopted person live together at any time as parent and child, or the natural parent was married to a domestic partner or a cohabitating with the other natural parent at the time the child was conceived, and the parent died before the birth of the child. And the second condition, the adoption was by the spouse or domestic partner of either of the natural parents of the adopted person, or after the death of either of the natural parent. So we're trying to get around this type of scenario. Because we're adopted only because dad died.
Yeah.
We're not adopted because we were given up at birth. We're not adopted because we're a drunk baby. We're not adopted out because mom couldn't care for us for financial reasons. We're only adopted out because my parents dead. My mom's still living with the same person, the same adopted dad that she's always lived with. And that's the only reason why I'm adopted. So it's a narrow section. But that's what that's going to talk about. So double inheritance is under 6451. Any questions on that one? That's going to be a very specific question, unlikely to get it because it's such a narrow fact pattern. But if you do, you just think double adoption, and pretty much somebody's got to have died.
I'm gonna say how they died, if they give them up.
Yeah, if they say how they died, that's going to be a crim crossover probably. But it's somebody that's one of the parents has to die. Okay. Okay, who wants to take a binary?
So this one was the adopting of your spouse. Basically, Amelia left a will saying my money basically goes down the line as far as it'll go until somebody finally dies without any kind of heirs. And after that, then it would go to the First Christian Church of Louisville, Kentucky.
Mm-hmm.
Ultimately, it kept going, except it got to their son. Yeah, it got to their son, or their son's kid, I think. Yeah, their son's kids. And the son married his wife, and then since they didn't have any kids, he decided to adopt his wife. That way she could continue to keep the money for the trust that his grandma had left.
Mm-hmm.
Ultimately, the church came after them because they wanted the money. They said, no, you don't qualify as an heir under the original will.
Mm-hmm.
You have to be basically progeny or some kind of child. And she said, no, I've been adopted. I should get all the rights and benefits. And the court ultimately ruled that when you're adopted as an adult, the rules are different. If you're adopted as a spouse, you don't count as a child under the adoption laws and the intestacy laws. Basically, they said that here, under Myra's will, that, or under the will of Amelia, Myra was not considered an heir and therefore could not collect the rest of the trust money. It had to go to church.
Do we all think that?
She should have kept the money of being the daughter.
But she was the wife. She was the wife of the grandson.
Well, legally she was the daughter.
Well, yeah, I guess legally she was the daughter, but.
So we also have to take into consideration there was a very specific provision in there that says it's in terms of whatever was the prevailing law in Kentucky at that time. So that's very specific. If it hadn't said that, we could just go on general principles. But the law of Kentucky at that time wasn't the same as the law of Kentucky when the trust was written. Okay, so how do we get around this? How would this have been fixed? Because who knows, maybe Amelia didn't want it to really go to the church. Maybe she really did want it to stay in the family. Maybe she really liked her stepdaughter or her daughter-in-law. So what could you have done in order to not have that result?
Well, instead of just putting heirs, you'd have to make it a more, I guess, you have to make it more open, yet also still more closed. So instead of heirs, you'd have to say children or progeny, which will include adopted children and so on and so forth.
Yeah. True.
Or just said my heirs or their spouses, and then you never would have had to adopt.
Yeah, I was gonna say you want to adoption thing.
Yeah, that would have worked. What about a power of appointment? What's a power of appointment? Yeah, so a power of appointment is the ability to nominate a beneficiary, essentially. So if there was a power of appointment, Amelia's son could have said, I invoke my power of appointment. I'm going to appoint my wife as my beneficiary for my portion when I die. So essentially that's what he was trying to do in this. He was trying to make up a power of appointment by essentially adopting his wife, right? He was trying to make another heir. He was trying to change the trust provisions to make sure that she got something. Because remember, we give to blood. We don't give to spouses. All of the rules of intestacy, all the rules of heirship, heirs at law, you're never going to see anywhere in the probate code where we're giving something to the spouse of my child, the spouse of my grandchildren. They're not giving any of that. So we need to be very clear about if you want to make sure it goes that direction, that's what you need to do. You need to put something in there. Better definitions in your trust. Better provisions for powers of appointment in the trust. So if we had this trust, let's say you were drafting Amelia's trust. You'd put in something that says, to my heirs or their spouses, right? So if you're doing that on the exam and you're trying to make this client, trying to create the trust for this benefit of this client, and this is their problem, they don't have any grandchildren, and they don't have any other children, but they really like their in-laws or their daughter-in-law, you're going to want to make sure that you have some mechanism in there that allows you to give it to them down the road.
Could we add that with the power of appointment?
Mm-hmm. Yeah, so you could say something like, to my child, and if my child deceases, he has a power of appointment. Great. Now that's pretty broad. Most of the time you're going to say something like, he has a power of appointment that must be exercised in a will or in a trust or a written instrument. But you say power of appointment and automatically you're at least giving that beneficiary some ability to create a new beneficiary later down the line. Okay? So that's very important. We want to have powers of appointments. We want to be able to say, okay, well, you, Mom, have made this trust and it's great, but I'm going to change it down the line because you gave me the ability to do that. So it's a little bit of a flexible provision. Okay? Oh, who wants to take O'Neill?
So this is the case of Haiti O'Neill and whether or not she was adopted by Roswell Cook. So in 1949, she was born out of wedlock and raised by her mother until 1957, so that puts her at 8 years old. Her biological father is kind of just out of the picture. So she was raised by her aunt until she was 12, and then her aunt basically gave her off to somebody who gave her off to somebody else, essentially, to Mrs. Cook. And the issue essentially is whether or not who had the ability to agree to the adoption, because she still had guardians out there, and even though the aunt was okay with the child going somewhere, whether or not the aunt really had that right. That's how I read it. And they said that no, she was never equitably adopted by the person that raised her from 12 until whenever that person died. So in the end, they're basically going with a contract theory.
Because adoption is a
contract,
right.
And equitable adoption is going to be very, very difficult.
Right. So do we have any inherent problems with this one?
It's kind of sad, I mean, but not really.
Right. I mean, there has to be some way of saying yes or no to an adoption.
Right.
And also, we want it to be in contract law, right? We have the statute of frauds for a reason. We want to be sure that what we're agreeing to is exactly what we're agreeing to, right? We all know what the statute of frauds is, right? Because that's in contracts. So that's what we have here. We have that same principle coming back out and proving that you can't just have an equitable adoption if there's no mechanism that would have been in place to allow that contract to be there. And it makes sense too. Well, what if I'm just tangentially related to somebody? I'm hanging out with this person's family a little bit, and then they die, and I say, oh, well, it's equitable adoption. They meant to, I meant to be part of the Gates family, right? Well, of course, you're gonna look at you and go, no, what are you talking about? There's no way to do that. An adoption is a legally binding contract, okay? So we're not gonna have equitable adoption, and you're gonna see it on the bar exam where somebody lived with somebody for a long time and there's nothing in writing, but for the fact that they were loved by this person, they were deemed a family friend of this person or a family member, and somebody's told, they've whispered to all of their friends that my daughter, XYZ, but it's not really a daughter. Now, does that person have any rights? No. Under O'Neill, no, because there isn't any equitable adoption. You either have to be adopted or you're not, okay? So we want to be sure that we're making the connections and the crossover connections of, if I have something like this, I'm going to say, well, yes, statute of frauds. There's nothing in writing. There's a contract here that doesn't have a contract. Okay, okay, what about the next case of Woodward?
And so this case deals with, in vitro fertilization.
Mm-hmm.
You have a husband who died, but before he died, he froze some sperm and just left it to his wife.
Mm-hmm.
And then, after he died, she conceived twins with this frozen sperm in vitro, and then now she's trying to get her kids to inherit money, saying, well, they are his descendants, even though they were born or conceived even after he died. The issue here becomes whether, are these really his descendants? And at the time, there was a question, are these his descendants? And what guidelines do we have in place to show that these are descendants to prevent fraud from other people just saying, oh, I was this kid long after the genetics of the father have decayed away.
Mm-hmm.
So, they put issues in, they put stuff in place where it's like, all right, if he froze the sperm, was probably his intent to later have kids, even though he wasn't going to be around anymore. But they put things in place, well, there has to be paperwork, there has to be, a genetic exam to, you have to give that, notice that these kids exist to all interested parties. So essentially there has to be a paper trail if you're gonna do this kind of thing, that these kids are related to this person, and then they can inherit it.
Yeah, so the court there took a really weak approach. They pretty much just went back down to the state court of Massachusetts and said, you figure it out. You need to work on your own statute, you need to work on your own legislature to figure this out, because the two competing sides were pretty extreme, right? The mother said all children should always inherit, and the IRS or the Treasury Department and Social Security said no children would ever inherit if you're posthumously born, right? Any problems that we have with this one?
Just the government.
Well, you have a bunch of kids saying, I was born this way, it wasn't how he died.
Right,
Or,
because,
is he a sperm donor? How many kids can show up saying,
Exactly. Right, and that's a good question. The court didn't consider that, but that's a good question. People in their 20s and 30s make a lot of money being sperm donors, right? They sign all these waivers saying that it's anonymous, et cetera, but that doesn't mean that somebody can't hack a system and find out who these people are, right?
There's a guy that's famous, he's got like 400 kids or something like that.
So we want to make sure that all those 400 kids aren't going to go attach themselves to his estate, because that doesn't seem equitable. Seems against public policy.
Well, they're not technically the natural born children of them, are they? I mean, even though the genetic material came from the father, if it's impregnated if that semen is impregnated for purposes into another couple, then once the baby pops out, for all intent and legal purposes, isn't that child a child of the birthing parents as opposed to who supplied the genetic material?
Yeah, I think that's the case.
For sperm donor, at least.
Yeah, so it's like surrogacy cases. But what if they made some sort of argument anyway? What if they only had one parent? What if they were adopted by just one mother and she had an anonymous donor? And they wanted to make some sort of claim, well, yeah, I have this one parent, but I don't have this other parent. And I have no adopted parents. Okay. Who knows? What if mom dies in childbirth? So now this kid is an orphan by a sperm donor dad and now a deceased mother, right? That child might say, well, hey a minute, this ain't fair. I'm gonna at least try to tax somebody. Whoever has pockets, mom's already gone, so let's go see if I can find this person, right? So yeah, there's contract rules that will prevent those types of scenarios, but the case in here, what we're talking about in Woodward is, let's make sure that there's some sort of consent, okay? So we looked at Probate Code Section 249, and this section is probably the best one in the United States because, one, we're very, very populous here in the United States, in California. We also have a lot of sperm banks. So that this is going to be appropriate for a lot of different reasons. We also have a lot of technology where people are creating babies posthumously, and it's going to be appropriate. So the 249, what does that say? So you can be considered an heir, you can be part of an estate, you can be an heir at law with two things. So the decedent had to have consented within 4 months of death, and it has to be in writing. So he can't just be talking to the baby mama and say, oh yeah, please go make a baby after I die. He's got to put it in writing, okay? Dear wife, I love you so much, I'm dying of cancer. Please, I want to have children with you, but, go do it when I'm not here. So that's the first thing he's got to do, or she's got to do, I guess, if we're going to free the eggs. And then the second thing is the kid has to be in utero within 2 years. We don't want, children being born 15, 20 years later and then disrupting an estate plan that's probably long gone, long finished. I mean, we have this new, example of this, what is her name, Bridget some model. She's in her 50s now, right? And she's married to a 35-year-old. She's 54. Well, she just had a baby. And she had a baby because she froze her eggs for the last decade. Now, if that had been the opposite, right? If her spouse had been the one who died, and now she has this baby 10 years later, that baby can't be part of the estate plan of that deceased spouse because it's over 2 years. And remember, one of the goals of probate in California is the timely administration of an estate. So we don't want to keep these things open for years and years and years and years and years. So if you have a question about a posthumous child, you got to remember a couple things. Did we agree to it? Right? Did I agree that I would provide for this child? And is it in writing? And was that baby in utero within 2 years? So technically the baby can be born within 3 years, but it had to have at least been started within 2 years, right?
That's a strict time.
It is. It is. And that's why this is a pretty interesting rule, and California is at the forefront of this technology because we have a lot of these cases that are coming up more and more and more because science is being a lot more efficient, it's a lot more accessible, and it's less expensive than it's been in years past, in decades past. Okay? Any questions on that one? Because that's kind of an interesting one.
There's like a little heartwarming story in there. The kid who froze his sperm as a teenager when he was going through chemo, so he got strong and he had his own kid later.
Yeah. But still, it's a strict, like you were saying, it's a strict timeline. 2 years, and you have to have consented within 4 months of date of death. So what if you consented, if you consented 2 years ago, but then you die, 2 years later, well, that's not going to work.
Oh, it has to be within 4 months of you dying?
Yeah.
You can't, have it
No,
as a provision of your living, of your advance directive to say, if I'm dying, take out sperm to give to my wife?
Unless you executed that will within 4 months of dying.
Oh, that's
This is like a deathbed. This is like a deathbed wish, right?
So can you make your trust, modify your trust within those 4 months to benefit this child that you might potentially have?
Well, at that point, if you're dying within 4 months, it's probably considered your mind's not there anymore. Yeah, actually, man, he's going crazy because he's dying.
Yeah. All right. So that's a fun one. I like that little ABC script that they had about Good Morning America. Not entirely sure where they even have that in there. Because I'm not really sure what 6-year-olds can tell us on anything. So let's think of another interesting tidbit too is, when we have Social Security benefits, that's governed by what kind of law? Federal. So it may not matter so much what our intestacy laws are in California, it's gonna matter what our federal laws are, right? So things like retirement benefits, if they're governed under federal rules like IRSA rules, there are gonna be different rules as to who's gonna benefit versus state rules. For example, there's a rule in the California Probate Code that says if you're divorced and you don't change your beneficiary designations, your divorced spouse doesn't inherit. That makes sense. I may have just forgotten to change my life insurance policy because my deadbeat husband, made me so scared to do anything. So California Probate Code says, okay, great, deadbeat husband, ex-husband, you're not going to get anything. If deadbeat husband had still been on my pension, my IRSA dictated pension plan, guess what? He gets it. So that's another little thing that we got to remember is when we're thinking about that beneficiary designations and intestacy laws, where is the asset and who's going to govern the asset? What entity is going to govern the asset? Is it going to be federal law or is it going to be state law? And it's very few examples that it's going to be federal law. It's going to be things like Social Security. It's going to be things like federally mandated retirement accounts or federally governed retirement accounts, pension accounts, things like that. But they might throw that one in there. If they throw an IRSA question, just remember federal might be different than state. That's probably enough.
How many times can federal money be inherited? down.
What do you mean?
Oh, like say you get your father's pension or something.
Mm-hmm.
Can you get your grandfather's pension? And
If you're designated as the beneficiary.
can that just keep being down forever?
Yeah, like if you want to roll it over.
Yeah, so every generation.
If you inherit it through a rollover situation, yeah, you can just continue to roll it over and inherit it. That's not going to make a difference whether it's federal or whether it's just some sort of state pension like CalSTRS or CalPERS or something like that. Okay. Now, if it skips a generation, there may be other rules. So let's say your wife died and your wife isn't going to get it, and it's going to go directly to your children. There may be mandated rules as to paying it out. And even if you inherit things like an IRA account, you have required minimum distributions. So if that's already started, if you're 70 and you've already started to get your required minimum distributions, those still have to come out. So that account's not going to survive forever, right? Because there's money going to be distributing from that account every year, no matter what.
But even when they die, I mean, normally you just take it and then open up your own IRA.
Well, you would want to roll it over.
Well, yeah, you roll it over into your own.
Yeah, but
And then designate your own beneficiaries and stuff like that.
Right, but pretty soon there's not going to be any money left because you were going to have already liquidated it because of those minimum required distributions. Okay. Okay, so who wants to take Martin? Since we're still on these conceived children issues.
So Martin died and he left 7 different provisions basically in his will to go to different people. One of them was his, there's so many people in these cases. So he died, he was survived by his wife and they had their son Lindsay, who had 2 adult children, but predeceased his son James, who died of Hodgkin's lymphoma. James, however, before he died, had his sperm taken out for the benefit of his wife to have children if and when she deemed that she wanted them. Mm-hmm. Ultimately, she did deem that she wanted them, and she ended up having, I think it was 2 sons? Yeah, James Mitchell and then Warren. And so he donated his sperm back in around 2001, and she gave birth in 2004 and 2006. And the question became, because the technology was not around back when Martin created his will, whether or not he intended for children that come after the posthumous kids, whether they would be entitled to the benefits of Martin's will through their predeceased father. Mm-hmm. And the court said that unless there is specific language otherwise stating that this is not what I want, then they are heirs and children of the predeceased as they would be if they were born if he did not die first. Mm-hmm. And so they're entitled to their father's share.
Okay. So now under California probate code that we just talked about, are they heirs?
Nope.
And why aren't they heirs?
Because she waited too long.
Right. Right. And so was it really in writing what he wanted with respect to it? We don't know. But first and foremost, the kids were born way too far after he died to even be considered under their current rules. Right? So we want to have these children after the fact. We want to have that conversation pretty close to death, and we want to have those kids in utero very, very soon.
You can't contract for a later time. Say like 5 years after my death or something.
Right, so can you contract around that probate code section? Mm-hmm. That's a good question. The courts haven't considered that yet. Okay. Probably not, because the courts in California don't like to interpret statutes that already have a timing on them. Right? This statute has a specific time on it. The kids have to be at least started within 2 years, right? So your point is, okay, well, what if I want to contract with my wife and say, well, great, I still wanted these people to be included, but for the fact that, they're not going to be born within 2 years. We don't know what the courts would say to that because it hasn't come up yet. That'd be first impression. My inclination would be that if it was pretty succinct and it was in the trust instrument itself, that it said that, probably would work. Because courts in California look to the four corners of the trust instrument, and you can pretty much say whatever you want as long as it's not against public policy. So if you want to say that, if you want to contract around that provision, you'd have to be specific about it. If it doesn't, if it just say my kids, that's when this code section is going to come into play. And you're not going to, it's going to be a little bit, it's going to be harder for you to win on that one. What about Slater statutes? Who wants to take the next one? The state of Mahoney.
So this comes out of a manslaughter case. Wife kills husband, then husband dies intestate while she's in prison. And the suit is essentially the guy's parents were appointed as the administrator, and so wife wants to succeed to her husband's estate.
Mm-hmm.
And they didn't allow it based on basically just public policy and a long discussion about it. It ain't cool.
Mm-hmm. So can we kill somebody and get life insurance policy proceeds?
No. It depends. Generally, no. Although there are some states where you can contract around it.
Yeah. So in California you can't. We have a Slater statute. So don't be killing anybody and then trying to inherit your estate. Our office actually had a case like this. It was a brother and a sister. Sister owned property, lots of property, and brother was her only heir. She had no children, right? She had no spouse. So we know under the laws of intestacy who's her next heir at law is her sibling, issue of parent, right? So he's going to inherit from his estate, but he is now frustrated with her, and he walks up to her house one day in La Quinta and shoots her dead. Okay, and sits on her corpse for a little while, goes back to Orange County, and then there's a probate estate that gets opened for her estate, right? Okay, so now he has children. And he's on trial for murder. And now the question becomes, well, who's the most appropriate person to run this probate, right? Is it his kids? Does that work? Is it some independent fiduciary? Does that work? And if he's convicted of murder, which he was, and so the probate has to stay open, right, to determine if he in fact is the slayer, who's going to get it?
Is California one of those states where they open up the constructive trust type thing and he holds it kind of as he's not the beneficiary, but he kind of like owns the trust, but he can't touch any of it? I forget what they called it. But, the constructive trust where they basically hold the money and it gains the interest or whatever, and then when they die, it goes to their kids, but they can't touch any of it.
Sort of. So here we are not going to let him inherit.
Does that just inherit his children as well?
Right. So
that just inherits his kids too?
Yeah. So is that what we think happens? What do you think?
It would make sense. I mean, he might have done it for his kids. So.
I feel like he would just act like that chain is dead.
Well, under per service, he should be kicked out, right? Because his line ended. Like he can't.
Well, but he still has kids.
I understand he has kids, but
you basically just are saying jump over that entire generation and go to the next line.
Oh, what if kids love grandma?
So you go to second cousins.
Well, what if kids love auntie?
But it's not the kid's fault. Like they didn't commit a crime. I mean,
unless you're doing it for the benefit of the kids,
I
but
know.
even still, they still probably have no idea what's going on. So it's your brother. So if we were to skip over, then it would go to either your grandparents or her grandparents. her aunts and uncles are her first cousins if we're just gonna skip over her brother and that lineage. But I still feel like the nieces and nephews would get it.
Nieces and nephews, so that means, so we have our dead lady,
Yeah,
You
the
probably do.
killer's kids.
okay, and dead lady has, she doesn't have any children, right? But she has a brother. Okay, the brother has a son. Okay, now, he kills her, right? And she's dead.
Yeah, I feel like you would just act like the brother's dead for all intents and purposes, and it would go to the nephew.
So you think that it goes here?
Yeah.
The only problem with that is that there's public policy involved for kind of the same reasons that, I mean, first of all, the son didn't do it, but at the same time, the brother may want that to go through his line just as much as collecting it himself. So, no, I think it,
I think it depends on. I think it depends on the state, because like in Vermont, it says that they did the constructive trust and that it went down to the slayer's kids. I honestly don't know what it is in California, but I would assume. Well, California is weird, so I can't say much.
Any other reasons why we shouldn't let son inherit?
Where we should.
Or shouldn't, both?
We should. I mean, the problem is the shouldn't end is his father is responsible for him getting it because he killed them, and therefore it's still an unjust enrichment type situation because the son, in theory, if he hated his aunt, would still give money to his father. I mean, that's kind of the dark side of things, but.
I mean, is there no one else for the daughter? It's just the brother and the son.
And
She didn't have any other siblings.
And there's no grandparents.
there's no aunts, uncles, first cousins, or.
No, she was like in her second.
Well, I think the other policy is that there's public policy against property going escheating to the state. So if there is a living heir that is not a slayer, then I believe that it should just go to them rather than to the state.
it should go to the son because, I mean, the policy kind of says that you can't profit off your own crime or wrong. And the son didn't commit any crime or wrong. I mean, there's possible reasons why the son, like, maybe it's not equitable, but those are like rarer than what's going on with the brother. The brother murdered his sister.
Oh, you phrase
It's different. What's going on here is different.
Oh, if you phrase it that you can profit from the wrongs or crimes of other people, and the son's can inherit.
But he didn't murder anybody. I mean,
But that's what happens.
he's not a slayer.
I mean, anytime anybody is murdered, somebody benefits from the wrongs of another. It sucks that it's your father that did it, but I mean, in theory, whenever somebody dies, it's at the wrong of another, unless they die of natural causes.
That's true.
So, I mean, I think public policy is it should go to the son rather than a sheep to the state.
Right.
It's not his fault that his dad went crazy.
Right, but remember, it's probably not gonna escheat to the state anyway. Because we're gonna find somebody. I'm gonna find somebody on this line.
You're going to find a family tree.
I'm gonna find somebody way over here, right? On the line of heirs. I'm gonna find some fourth, fifth cousin over here.
Well, not if there is nobody. I mean, if grandparents just had their parents and they just had their daughter.
Yeah. I'm gonna go with this New York rule.
What is the California rule?
Yeah, I mean, what is the California rule?
I'm gonna let you sit on it for a while.
Alright.
I still say son should get it.
That's the consensus, is that son should do it even if,
Yeah, because it's not his father's fault. I mean,
Well, it's not his fault.
I mean, well, it is his father's fault, but it's not his fault. His father did that.
so we think that it's fair?
Mhm.
Even though son is inheriting through dad. It's the only way that son gets it is because, let's say that there was some other third cousin here. or second cousin, right? So there is another beneficiary, okay? On this end. So son's only getting it
Because his dad killed.
because dad's deceased for purposes of this example.
Yeah.
Still think it should go.
Well, it's just like gonna feed the sister's money into the dad's commissary. I mean, what is he
Right.
getting unfortunately?
And is it fair to let your heirs inherit? That's essentially a benefit to dad.
But I think it depends on. I think it depends on the reason, if it comes out, the reason for the murder. I mean,
Right,
if brother killed sister for benefit of the son,
but then you're gonna go down for the murder anyways in California.
Right.
And that's
Yeah,
why
and then
the
you're a
son-
slayer too.
yeah,
well, no, I'm just saying, son has no idea. Brother just says, I'm sick of my sister. I want to get the money for my kids so that he's set up, but he's not a co-conspirator or
So you-
anything like that. You're just killing your sister so your son benefits. Then I don't think that he should get it. But if brother's doing it for selfish purposes, as far as I want my sister's estate,
Mhm.
then I think it should go to the son, because you're not doing it for the benefit of the son. So say you know the Slayer statute and you say, I'm not going to get it, but my son will get it if I kill my sister, then
My heirs still benefit.
yeah,
My line still
then I
benefits.
don't think that the heir should get it if that is your reason for doing it, if that makes sense.
Okay. So you're a little more nuanced about it.
Yeah.
I mean, I think these are all good things. You're pretty quiet over there.
Just
Victor's always quiet.
yeah, just like what he said is just. But then I'm like, there's really no way to know the killer's true intent, unless he says it outright. You'd be very lucky if you actually.
You're not gonna get that, right? You're never gonna get that.
Exactly.
Okay.
I think you have to defer to some kind of statute and hope for the best and hope there's no exceptions. Otherwise, you have to do it on a case-by-case basis.
Right.
And then that would just take a lot of time and effort. State's fine, and won't pay for that.
Right. Right. Okay.
Can you inherit like outside the U.S.?
Oh, good question.
Yes.
So what do you mean?
Because like if you try to trace my ancestors back, you got like 2-3 generations before you're in Mexico.
Mhm.
So like I do have like a ton of cousins. So when my stuff, the probate courts or whatever, go through the effort of finding me to send to Mexico and then be allowed to send my property over to a non-citizen.
Yep, because the statute doesn't say you have to be a citizen. The intestacy laws just say heir. And if you're under the definition of heir, if you're a second cousin, or you're a niece, or you're a nephew or a son, or any of the things that is defined as an heir under those 240 and the 6400 statutes, I can give it to you. There are lots of clients that have heirs all over the world. Now, here's the question. What happens with that property? Is it taxed when it goes over there? Because there's a different issue.
Yeah.
If I send property to another jurisdiction, is that going to be a ramification for that beneficiary?
The export taxes.
Well, when
Not an export tax. It may not be an export tax, but it might be an income tax because they might not have the same gift rules that we do. I know that Miss Ebar went over gift taxes with you last week, right? So if you receive property in California, you're not going to pay any taxes on it. You received it. You received that property. You're not going to pay any taxes on it. But if I send property to another jurisdiction, if I send it over to, who knows, Australia, for example, they might be taxed on it. And so the kicker becomes, do we have a tax treaty with that jurisdiction? If I have a tax treaty with that jurisdiction, probably no problem. They're going to have to declare it when it comes into their bank account through a wire of some sort, and then they're fine. Now, if I'm sending money to Dubai, if I'm sending money to Jordan, if I'm sending money to any other places where we may not have a tax treaty, that might be a huge tax problem for that beneficiary when they get money coming in. Another problem with our our foreign friends is I'm gonna have a huge problem if I name a foreign person as the trustee of my US trust. The US government doesn't like to do that. The US government hates it when I have some foreign person in charge of assets in the United States. What do you think that is?
They have no control.
Exactly. Guess what? That foreign person can go, I'm gonna wire all this money now to Switzerland. Peace out. Right? So they can't control it. So what happens in that scenario is that now that trust that has now been created by a California attorney and has all these assets in California, et cetera, is now going to be called a foreign trust. Because I have a foreign person in charge of that trust. Don't do that. We don't want to do that. It's a terrible idea. It causes a lot more issues on the tax inside. There's a lot more reporting requirements. It's a huge pain. Don't do that. So if you have a scenario where you have a whole bunch of beneficiaries or you have a whole bunch of potential people who want to be the trustee, who want to be the beneficiaries, great. They can be beneficiaries. I don't care. That's fine. Do not name those people as your executor or your trustee in your trust. Right? Unlikely to come up on the bar exam, but if it does, don't give them any authority. Right? That's like the goal. Don't give anybody who's outside the United States authority over any of your will and estate documents. Okay? But good question. But no, I can send money down to Mexico. That's not a problem. I send money to Canada, I send money to Australia, we send money all over the world for beneficiaries. Not a problem. But it's a problem if those people are trying to be in charge. We don't have to do that. Okay? Okay, what about disclaimer since we're on the tax question here? What's a disclaimer?
Like, oh, so that's just when they decline to take it.
Mm-hmm. But where does it go?
Well, then it would go to.
Can I tell you where it goes if I just spent, let's say I'm getting $1 million and I want to say, okay, I disclaim it to my daughter.
I don't think.
That's correct. You can't do that. That's
No,
what I'm
because
saying.
it's a gift, so you either accept it in whole or you deny it in whole, right? You can't pass it.
You can't.
Unless you
it's
accept
not,
it.
You can, but it's not called a disclaimer. That's called an assignment.
Yeah. But you have to accept it first, don't you?
No? I mean, yes, you're technically treated as accepting it for other reasons, like tax reasons, but it's never going to actually hit your pocket.
Yeah, so
you don't have to actually, get it. But so there's two ways that you can say, I don't want this property if I'm a beneficiary. It's a disclaimer or it's an assignment. Disclaimers are going to come up. If you get an estate question, it'll probably have some estate tax issues on it, and there may be a disclaimer. So important things to remember about disclaimers are, I'm treated as not necessarily ever having it. Asterisk, 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 except for the federal government. Right? So if I'm on public assistance benefits, if you get a question that says you're on Medi-Cal, if you get a question that says you're on Medicaid, that's a public assistance benefit. If you're giving a question that says any of those things and you're inheriting property, automatically you got some problems. And don't say you can disclaim it, because you can't. Because even if you disclaim it, the federal government is going to say, no, I'm still treating it as though you got that property. And now you're kicked off of those benefits. Okay? So you can disclaim it for other reasons, but you can't disclaim it if you're on public assistance benefits. And you'll know it's public assistance benefits because it's going to say things like Medi-Cal, Medicaid, Social Security income, disability benefits, SSI. All of those things are sort of codes for I'm on public assistance benefits, and there might be a problem if I inherit property. Now, in the real world, you're going to inherit $10 million, and you have Medi-Cal that's giving you $50 a month, and maybe SSI that's giving you $150 a month. Do you care? No.
Yeah, I want my Medi-Cal.
Yeah, but right,
Yeah,
that's the real world thing. I know you'd actually be
If you die of
surprised.
cancer or something,
Yeah.
You're going to get $50,000 and you have
yeah, and
medical bills. I mean,
and you have some horrible disease, like it could happen. It's unlikely,
Mhm.
but it could happen.
Yeah, so if that does happen, and if you do get that, the real world consequence is you get kicked off a Medi-Cal until you spent down all your money. Well, you're gonna spend it on your medical bills.
Yep.
That's what you're gonna do with it. So you're actually not gonna have any of that inheritance for anything that you wanted to use it for. Right? So,
Cut out the middleman, send it straight to the hospital, assign to the hospital. You're gonna take it anyway.
right?
Don't stop my treatment, just keep it going and then.
So what are some examples? What do you think you could do to get away from that? I know it's not in this material, but creatively.
Well, you could set it up. I think they talked about it somewhere in there. Set it up in a trust. So, like we talked about with Nicole last week. So you never actually have ownership of that money. It's in a trust for the benefit of you, and there's a trustee set up to give you your allowance out of it. Therefore, you never actually have control of those funds. It is set up to go to somebody else for the benefit of you.
And what's that called? Do you remember?
I don't remember.
Yeah, we should do a specific name.
That's a little different. It's called the Special Needs Trust.
Special needs trust.
Oh, yeah, I think she called it like a MFBT or
So
something.
that's
like that.
different. That's a Helm standard. That's not for this purpose.
Oh, okay.
That's just a trust for your benefit. If you want a discretionary trust, but that trust money is going to be determined to be yours. Remember, in this scenario, I'm on Medi-Cal. I don't want that trust money to ever be called mine. This money is always going to be outside of my name. It can never be considered my money for any purposes. And the only way you can do that is not through a disclaimer, right? The only way we can do that is if this money was given in a special needs trust for my benefit, or you went to court to set up a special needs trust before I inherited the property. So unfortunately, I have cases like this now. I have a guy who is getting a house. Well, that's fantastic, but he's on SSDI, he's on SSI, and he's on Medi-Cal. Well, that's great that he's gonna get a house, plus a whole bunch of other money, but it's only gonna hurt him, right? He's got AIDS, he needs to have these benefits, he needs to continue to have these things, right? So we have to go to court to set up a special needs trust. And how does that work? You go to court, you get a special needs trust set up, and you direct that the money that would come in through an inheritance doesn't go to him. It goes to this trust that I'm setting up.
Can you do that after the person died or before they inherit? Like in that window?
That's the only time you can do it.
Okay.
Because otherwise, if mom was still alive, she'd just change her trust. And she just put those language in her trust already. But this is the scenario where mom's already dead, and I have this money coming to my client, and he's freaking out because he wants to continue to be on this public assistance benefits. Well, I want him to stay there, but he's going to inherit, $500,000 house plus a $300,000 stock account. Well, that's $800,000 that Medi-Cal is going to say, wait a minute, now you're off. We don't want you on these benefits. Okay? The problem with that is it's very expensive to do. It's not easy. You got to go to court, you got to set this up, etc. Okay? But that's the way to do it. It's not to do it through a disclaimer. Okay? Now, how else do we use disclaimers for estate taxes? Do you remember?
Taxes.
Well,
Let's say my husband and I have $25 million. And the estate tax right now is about 11.2. It's a shy under 11.2 million. So my husband and I have more than $25 million. Right? So how are we using the disclaimer for my advantage in that case?
You wait 9 months?
Yeah, you have to do it within 9 months.
Oh, you have to do it within 9 months? I thought if you waited past the 9 months.
You just didn't have to do it anymore.
The IRS doesn't like that. So within 9 months, I want to disclaim some property. So basically, I'm telling the IRS, this is my property anymore. It's property that belongs over here. So it's going to be, put into some sort of marital trust, credit shelter trust, bypass trust, something like that. So that's not going to be included in my estate. It's going to be disclaimed and included in my husband's estate.
It says it has to be a qualified disclaimer, but it doesn't define what a qualified disclaimer is.
So that's basically just, it's in writing, it's unequivocal, it's irrevocable, and it's within the time frame set out by the IRS, right? So you can't take it back. It has to be final. And why do I do that? If I die and I have $25 million in my name, what happens?
It goes to your spouse.
No, my spouse is dead.
Oh, then it goes to your kids.
Yeah, but is there a tax problem?
Yes.
And what's the tax problem?
Is that anything over the 11.2 is going to be taxed?
Right. And do we know what that tax percentage is?
Probably it's like, I think it's like 50%, isn't it, or something like
Just
that?
shy of 50. About 40 to 50, 44, 47%. That's a lot of money, right? Now, when my husband died, if I had disclaimed some property and put it over into a bypass trust, or I funded it and I got it away from me, then when I die, I only own the half that's left, or whatever amount that I didn't disclaim, right? So now I've successfully avoided estate taxes for both of us.
$25 million.
Well, let's say it's slightly less, right? So let's say it's like $22 million. So that we're not gonna owe any taxes on both of our debts.
Can you do a partial disclaimer? So, disclaim, I want up to the 11.2 million and I don't want the rest?
That's not a partial disclaimer, it's just a disclaimer for that amount.
Oh, okay.
Remember, the disclaimer has to be irrevocable. So,
But that's what I mean, I am accepting 11.2 million and I don't want the rest, forever and always.
I disclaim the rest. Yep.
Oh.
I mean, you're gonna have to fund it in different mechanisms. So you're gonna have to fund an A trust, a B trust, and a C trust under that. If I do have 25 million and then both my husband and I are over that exemption amount for each of us at 11.2, that's gonna give us 22.4 million, right? Now I'm over that. Under that scenario, I can disclaim, but I have to fund these separate entities in order to do it properly. I'm still not gonna pay any estate taxes on the first death. There will be taxes due on the second death under that scenario, because I have over the 22.4 million. I've got about 3 million extra.
So would it be like 7 million in taxes?
No, because it's only about 3 million that is owed, and it's only about 40% of that 3 million. Okay, so it's a little over $1.25 million that it's gonna be owed. It's a lot of money. It's a lot of money. Now, we've never had an exemption this high ever in the history of the United States. I mean, the last time the estate tax was high was under President Obama, and that was at 5 million, indexed for inflation. Now it's over double that, right? So if you get a estate tax question, you gotta have a really wealthy person. I mean, you're gonna have to have 2 people that have over $22 million, or 1 person over 11.2, essentially.
So it splits it up by the amount of beneficiaries of the money. So, not beneficiaries, but the amount of principals to the money.
Yep.
So if there's 2 people, then they
If they're
each
married.
get 11.2 million.
Now, here's the kicker. What if they're same-sex partners? Do they still get it?
I would assume so.
Yes, they do. And that is exactly the case that we had in 2013, which was the case where the lady had inherited money from her spouse in New York, and that's what her problem was. She owed all these estate taxes. Well, they were married in New York. So they were married, but the federal government said, well, wait a minute, you're not married for our purposes, right? So you can get a same-sex couple and they will get the marital deduction. They will give both of them having that 11.2 million. So if you get, a question on the bar for purposes of disclaimers, you're gonna have estate tax, so it's gonna be a really wealthy person or couple, and remember 9 months. Those are the 2 sort of highlights that you gotta remember.
Wait, what was the 9, sorry, can you say that again? Just so I have it right, what would you say?
So if you're gonna get a question on the bar that's gonna deal with disclaimers and estate taxes, you're gonna see a couple of fact patterns that are gonna be similar. They're gonna be very, very wealthy.
Okay.
I mean, very wealthy. $100 million, $50 million, okay? And you're gonna remember that it's 9 months. So if dead guy died a year ago, a disclaimer's not gonna work,
Okay.
right? So it must be disclaimed in 9 months. You gotta have a dead guy that's not been dead too long. Or a dead girl, but most of the time we kick off them. Okay.
So if you do disclaim after the 11.2 million, your 11.2 wouldn't get taxed because it's below
Stays in you.
it's below
Yep.
that.
Yep.
But so say it's a $20 million trust. Would the remaining 9.8 that you don't take get taxed at the 50% rate for whoever takes it? Or is it just 11.2 per person who receives it?
Not receives it. We don't care about who receives it. Not right now.
Okay.
Okay. So we have wife, and she gets 11.2, right?
Mm-hmm.
Okay. And for purposes of easy math, we have husband, and he had like 7.8, right? Because we had a $20 million stake.
Mm-hmm.
So I'm not taking his 7.8, right?
Mm-hmm.
But my husband still got that amount when he died. He still was allowed to have his 11.2. So there's no estate tax due on his death, and there's no estate tax due on my death.
Okay.
Because it's over that 22.4.
But say it's like one person that has a $20 million estate, and they die, you disclaim, you accept up to the 11.2 million, and you say, I don't want the remaining 7.8.
Well, who's the dead person, and is the dead person married?
So say it's your mom,
Mhm.
and they're single, and they're just extremely wealthy and have a $20 million estate.
Okay.
And it's just, so you're their only kid.
Mom has 20 million?
Yeah, mom has 20 million.
Okay.
You're their only kid, and then you have a kid. So mom dies,
okay.
You're gonna inherit it, but you don't want the taxes. So you take up to the 11.2 million and disclaim the remaining 7.8.
No.
You can't do that, right?
No.
You basically either have
Because
to.
mom's not married. She's not going to disclaim it for her benefit to give it to somebody else.
Okay.
And a disclaimer, remember, a disclaimer doesn't work to allow a kid to give it somewhere else. Like maybe under your scenario, you're thinking, okay, I'll take my 11.2.
So it's not taxed, and
Yeah,
then
and then I'll give something else to, Desert Cancer Foundation, right? Because they're a nonprofit
Mhm.
and they're a charity, so they don't have this deduct. You can't do that.
Oh.
That's an assignment and it doesn't work.
Okay.
So on this scenario, kids inheriting, and of that 7.8, you're going to pay taxes on the 7.8. You're just going to do that.
Okay.
Sometimes what you're going to see is mom's going to say, I fund to kid an amount equal to the estate tax exemption, and the rest is going to go XYZ charity in Phoenix, Arizona. Does that work?
Mhm.
Yeah. Sure. Why not? No. I've now avoided estate taxes. My kid doesn't get the 20 million, right? And my kid probably gets less than if my kid had just paid the taxes, right? Because if my kid pays the taxes on the 20 million, he's going to get the 11.2 million, and then he's going to pay taxes on the 7.8. He's going to pay about 3.5 in taxes. He's still going to get, 13, 14 million, right? That's more than if he had just taken the 11.2 and the rest went to charity. Right, so state tax questions are going to be, again, very, very, very wealthy people. It's going to be 50, 60, 70, 80, 90, $100 million. A couple of that dies. $5 million in this day and age, peanuts, right? Because we have $11.2 million as our exemption. Technically, it's a little less. Technically, it's 11.180, but for all intents and purposes, we call it 11.2. Okay. So estate taxes are kind of a big wonky thing because not a lot of people understand them. And they like to get you on them on bar questions. Because again, how do you plan around it? Okay? And a disclaimer, again, you're married. You're going to disclaim your portion, so you're not going to have it taxed. It's got to be within 9 months. Those are going to be your questions. Okay? Those are going to be your fact patterns that you're looking for. Okay. All right, shall we take a break?
Sure.
How about 10 minutes?
Wait, did we decide if the kid gets the money from during debt?
I looked up the code. The code doesn't really say. It just says a person who feloniously and intentionally kills the decedent is not entitled to any of the following, and it's basically their estate. But so if they're not entitled to it, I guess I would argue that statute to read if they're not entitled to it, then their entire line isn't entitled to it, and it would go to the second cousin. But I still don't know if that's right or not.
Do we know yet? Like, is there a rule in California? There's a case out there?
Uh-huh.
All right, I'll have to find it.
Oh, yeah.
And how are you, madam?
I'm good, how are you, John?
Good. What are you doing today?
Intestacy.
Oh my
All
goodness.
those fun things.
Oh my goodness.
How do you
I forgot to have a will.
Yeah, I forgot to have a will, exactly.
Do they still have the lines of consanguinity?
Uh-huh.
And is that part of what you do with intestacy? I
That is
suppose it
exactly
is.
right, yeah.
It's the only thing I remember.
Yeah.
I could do that on the exam. I could write that down.
That's all you need.
That'll be probably about it.
Yeah.
Okay.
So, the one thing about page, like, you really should exclude, like, I want to show you my notes.
Okay, one second. Okay.
Do you want something?
I have a
Snack?
I'm good.
Okay.
Yeah, you're all right. You guys are rolling along. Get it in now.
Oh, I think we had earlier, and I saw you about your flower, and I was like. Because, you know what? When you're it's like, I remember anything. Like, I'm looking around like, maybe I'm like, you know, before I start, I'm like, oh, I got this. It's a good thing. And then when it's all like, I don't know. So I get it. I'm like, it's there, so I still have to do that. But when you're sitting there and you're all doing your case, yes, you have your like, oh, right? Your head, yeah, okay. That's all I
Says, right on the bottom of that's. Yeah, and I didn't know what was straight before that. Not that, I think we have to so both back. And he just came here, he says, sit over here, sit check. And he asked me to sit check. Yes. Clearly,
Did you guys watch Law and Order? I used to watch it. Because they always went outside. Didn't they?
Yeah, they kill our house.
Yeah. Yes.
No payments. That one has to have some serious business.
She's bipolar, and one of the medications that she takes, she claims has a stated side effect of hypomania.
Side effect of the medication.
Get an expert in there and say, Your Honor, yeah, yes, she had a long transaction with them to get it in Canada, they saw her take it, and then she transferred all her things, and she signed it all. But then she got that settlement with the rest of her, they while she was in there. And they arrested her, and hung up her in for 5 days.
What the program? What's the 19th of the week? That's this Thursday. No, that's October 9th. Better take that 19th.
Wallet.
Who wants to call it?
I'm gonna have you answer that question before next week.
Before next week?
But I'm gonna give you a hint. It starts at probate code 250.
Well, yeah, that's where I found was probate code 250.
Okay. Then it puts you on a little bit of a wild goose chase because it's gonna throw you into some other statutes. Like 21-110, for example.
But there's a lot of different statutes in there. Wait, what one did you say?
Oh, 21-110?
Passes the property interest or benefit referred in paragraph 1 of subdivision A passes as if the killer had predeceased to decedent. Deceased transfer divided in sections.
So you're gonna probably have to do some graphs. So, Will, I was just saying that this question about the Slayer statute,
Oh, yeah?
I'm gonna have you guys continue to think about it.
Okay.
And I'm gonna give it a starting point. It's in probate code section 250, but that's not gonna be the ending point. Because you're gonna go on a little bit of a wild goose chase to try to find the answer.
Okay, okay.
So it can't be like the Ron Swanson will. They can contract around it, say, give everything I own to the person that kills me.
No, because remember this scenario, he died in testing. Okay, so let's continue on a little bit with disclaimers. Can we disclaim things to get around, let's say, the IRS?
I feel like no.
Well, no, because you said for anything that's government related, or you say government benefit, but I'm assuming the IRS is just as wanting as.
IRS is pretty mean.
Right, so if I have a $500,000 tax lien, because I didn't pay my taxes for a decade, and I'm gonna get a windfall. And I'm gonna get, let's say I'm gonna get a $500,000 from my mom's estate. And I say to myself, well, if I get it, the IRS is just gonna take it. I'm just gonna disclaim. Can I do that?
No.
Why not?
Because it's the IRS.
Right, essentially, that's why. They have a superior lien, right? They have a different version of events and they operate on a different level of rules than anybody else does. Right? So you can't get out of a debt and disclaim it and say, okay, fine, not mine. You can't do that.
Okay, so I guess an ethics question.
Mm-hmm.
How do they know?
Good question.
I mean, it's not like it's reported to anywhere. I obviously, if it's a bigger estate, it has to go through probate court. But is it just a
And even in probate court, does the IRS get notification in a probate?
I don't know.
Not
I
necessarily.
don't know. I don't think so, but
The franchise tax board does. Do they communicate? Sometimes. Not always. So yeah, that's the next ethics question. If you get it and then you turn it over somewhere really fast, are they gonna see it? Maybe, maybe not. Tell you what though, the IRS has a tricky thing that they do. They put liens and they notify banks. Wherever you have your social security number attached to your bank, there's gonna be a lien on it. So the minute money gets in there, boom, they're gonna know. So that's how they know. It's because they will have already put out feelers to any place, they've already done their research, and they're gonna say, okay, you have a bank account at First Republic, you have a bank account at Wells Fargo, blah, 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 blah. I found all these banks, they're tied to your social security number. That's how they'll know.
And that was recent, right? Because the
Patriot Act. Yep, with the Patriot Act, yep. So that's how they'll know. If you get it in cash, that might be a little different, right?
you
But
can't put it in the bank.
you can't, yeah, you're gonna sit it under your mattress, and your mattress is gonna be pretty high, right? So that, but they will find out that, okay? What about creditors? Let's say I owe Joe Blow down the street $50,000, and I don't want to pay.
Can you get around with a disclaimer?
Mhm.
I would say yes if it's Joe Blow.
Yeah, there's not a whole lot that Joe Blow can do about it, right? He can't force my hand and say, well, you have to get this money. I can say, well, I don't want the money, right? Okay, so no for the IRS, yes potentially for creditors, okay?
on your trust, add that all money be inherited in cash.
Yeah, in cash.
So there, we also have what's called a
Sure, stop
spendthrift. A spendthrift clause. Do you know what a spendthrift clause is?
Is that like where they have issues if they are, is that like the one where Nicole had talked about where if they have issues and you, like issues spending their money, so you don't want them to spend it all at once, so you put it in a trust and they get their allowance out of it or something like that?
Sort of.
Oh.
This is more like Joe Blow's got this creditor claim against me, and my mom's trust is being administered. Joe Blow can't go to my mom's trustee and say, hey, trustee, you need to pay me because Heidi's getting some money. And then it's just gonna go to me. Well, my trustee, the trustee of my mom's trust, is gonna say, there's a spendthrift clause in here. The spendthrift clause says that that beneficiary doesn't own it until they actually get it. So no creditors can make any claims for my inheritance if I haven't actually gotten it yet. Right? So yeah, maybe the minute I get it in my account, they're gonna sue me, they're gonna get a judgment against me, they're gonna try to get that lien on my bank account, but a spendthrift clause is gonna prevent those creditors from actually getting any of my money before I get it.
Including the IRS or not the IRS? They're still above that.
They're above it because again, they're gonna get
Or
it.
the IRS.
Yeah.
We'll find a mattress.
Mhm. And even in the IRS statutes, we can say to the IRS, well, you know, IRS, you can't actually attach to this whole trust that's for the benefit of this beneficiary because the beneficiary is only getting $5,000 a year. So the IRS is only going to be able to get that $5,000 a year on a yearly basis. The IRS isn't going to be able to go in and say, oh, there's actually $2 million in here. I'm going to get it. Well, I don't actually own that $2 million. I only own $5,000 a year. Okay? So that's what you want to see in there too. Okay, so we can't avoid taxes. We can potentially maybe avoid some creditors. And we don't want to use disclaimers for Medi-Cal and Medicaid. Any questions on the casebook before we go over to our supplement and review some stuff on the supplement just to review it? So let's recap intestacy. who gets what? First generation is me, my children, again, we're ignoring the fact that I'm married at this point. First generation is me, my children, and my grandchildren. That is a lineal, because it's a line, a lineal descendant chart. Okay, those are my lineal descendants. Now, if I don't have any lineal descendants, where does it go? It goes up a notch. To who?
My mom and dad.
Mom and dad. Mom and dad have died. Where does it go?
Brothers or sisters, please?
Brothers and sisters. And if they're not there,
Nieces and
nieces and nephews. And if that line doesn't exist, we're gonna go to grandparents. An issue of grandparents. An issue of grandparents. And all down the line there. Okay? So when we're going to the right of that chart, those are collateral heirs. They're not lineal heirs. It's unlikely you're gonna get a word like collateral heirs because they just probably don't even use them, but that's what those heirs are called because they're not in the same line. Okay. Now remember, if you get a husband or a spouse in here, you're gonna throw this out a little bit because you're gonna have some other interesting questions about who gets what. And if you get one of those, you're gonna also be thinking about community property issues, right? So if I own this house with my husband and we've been married for 40 years and we bought this house 20 years ago, is that community property or not? Probably, right? All intents and purposes say it is community property. Now, you ask yourself, do I have a premarital agreement? Yes or no? Do I have a postmarital agreement? Yes or no? If it doesn't say anything, you assume no, right? And under that scenario, I have one husband, I have a house, and we just said it's community property. Who gets that property?
Did you both die?
No, only my husband died.
Well, then your husband would die. Oh, your husband would get it. Or no, if your husband died, then you would get it.
Yep, and I,
Because it's community property.
exactly. And I inherit all of the community property of my spouse. Because I already own 50%. So my husband, he's gonna have his 50% and I'm gonna get it, right? Now let's say I inherit 2 pieces of land in San Francisco. Let's say I have 2 little condos in San Francisco that I inherit. I inherit that from my mom. And it's still in my mom's trust, but I just haven't changed the name, so it's mine. And then I die. I have 2 kids and I have a spouse. Who gets those condos?
And get split between your kids.
How?
50-50.
1/3, 2/3. Right?
Um,
Because I have more than one child.
that's if you die in custody, right?
Correct. Correct. Okay.
So can they divide them up or do they have to sell them?
Depends. I mean, it depends on who my administrator is. It depends on who my executor is. So what's the difference between an administrator and an executor?
And it's the kind of instrument, isn't it?
So which is which?
An executor is the will,
Yeah.
and an administrator is an estate. Yeah.
Intestacy and or not somebody in my will. Okay. And a personal representative is who?
A what?
Term.
A personal representative is either of those. You can call yourself a personal representative if you're an executor or if you're an administrator, it doesn't matter. You can be either of those 2 things. Okay. And again, how far along does the line go before we go to the state, before we sheet? It goes pretty far. So let's say we can't even find somebody on my line. I don't even have a 5th cousin, a 4th cousin. Who else can potentially inherit that you wouldn't think would inherit?
Do you have a spouse?
I had a spouse.
You had a spouse.
My
So then your
spouse
spouse's line could probably inherit if you don't have anyone in your line.
Correct. That's weird. That's like an odd thing. You wouldn't think about that. And the public policy generally wouldn't give it to us predeceased spouse's children. Those are now my stepchildren. But it does. And that's why it's very rare for any property to ever escheat to the state of California. So if you get a question and you have nobody, and it's pretty clear you have nobody, but you have a stepchild, and your spouse didn't die that too long ago. And then are you gonna go to the state or are you gonna go to your stepchildren? Probably gonna go to your stepchildren. Okay? And remember, you're gonna look at 6,400 for those lines of where is it going, the incestacy lines. And it's gonna be different. It's gonna be different if it's real property or personal property. Okay, we allow my predeceased spouse to have died longer ago if it's real property than if it was personal property. I think it's 15 years for real property. And only 5 years for personal property. Okay. Let's talk about some terms for a will. So we were saying the word codicil at the beginning of this lovely little evening. So that's just essentially it's an amendment to a will. That's the only time you're ever going to hear that. And you're never going to say a codicil to a trust. That doesn't exist. That's a misnomer. You're going to say a codicil to a will only. And that is literally the only time in your whole life you're ever going to use the word codicil. An amendment to a trust, it just means that you're changing some provision of your trust. Okay? Could be a page, could be 2 pages. A bequest and a devise, what's the difference? Yeah.
A devise is a gift of real property and a will, whereas a bequest is a gift of personal property.
So if I give you Blackacre, what's that?
That's a devise.
Right. So if you get a question, and that says that, this devise fails for whatever reason, it's gotta be dealing with some real property. It's gonna be a house, it's gonna be Blackacre, it's gonna be a condo, it's gonna be a government building, it's gonna be whatever, it's gonna be something that's tangible, that's attached to land. Okay? A bequest is just a very simple, anything pretty much that's not real property. Okay? Beneficiary, that's easy. That's whoever gets it, right? What's the difference between a beneficiary and an heir?
Beneficiary is designated in a will or a trust, whereas an heir is in your line of intestacy.
Right. Because intestacy is already an estate plan. It's just the state of California's estate plan for you, right? Because it is an estate plan. So your heir is like your beneficiary, but under an estate plan that the state of California has created for you. So your heirs will always be the same people. You can never not have, you can never say, this person isn't my heir. That doesn't exist. The state of California has defined who your heirs are. That may not be your beneficiary if you put something else in writing. Okay? So you can't change your heirs, you can change your beneficiaries. Right? Heirs are defined by statute, beneficiaries are defined by instrument. Okay, what about a grantor? You think that, but it's also the same term as a trustor or settler. It's somebody who creates a trust. So if you create a trust, you're a settler, you're a grantor, you're a trustor. All of those terms are interchangeable. There's nothing different about them. It's just phonetics. It's just semantics. Okay? So if you have a question that says, the grantor made this trust and whatever, the grantor did this, you know that that's the person who owned the property initially. Because the grantor is making this trust, is putting some property into trust. Okay, same with settler, same with trustor. Okay, trustee, what's the difference between a trustee and a trustor?
The trustor owns the trust, and the trustee is a beneficiary of the trust.
Not the beneficiary.
Trustee manages
it.
Yeah, essentially the manager.
Okay.
Okay, so a trustee can be a beneficiary, can be, doesn't have to be, but that's not their goal. That's a fiduciary role. So the trustee is somebody who is, let's think of them as a manager, right? Usually when you set up a trust, the trustor and the trustee is the same person. Because why wouldn't you just manage your own trust? Okay, you can do that. Principal and income, if you know anything about math or bank accounts, principal is just the overall amount in the estate, and the income is just the actual income that's earning from that trust. Okay? Do you have a question about that, Victor? Okay, so are we common law or community property?
Community.
Community property. So really pretty much anything about common law, we don't care. Right? I mean, it's interesting, I guess, but we don't really care. We have community property rights here. So again, you know, not to keep harping on it, but these are the kind of questions you're gonna get. Husband and wife have a house, it's their community property, or it's not gonna say it's their community property, it's gonna say that they built the house together, they've been married for 40 years, they've owned the house for 20 years, and then husband inherited a CD from his mom 6 months ago, it's always been in husband's name, husband dies without a will. And you gotta figure out, okay, who's getting what? Well, we know that the house is going to wife. We've beaten that one pretty down, right? Community property is gonna go to your spouse. Now that CD, you're gonna have to look further in those fact patterns to see, are there any children? Are there any children's children? Do we have this, do we have that, and where's it gonna go? And you gotta remember, is this community property or is this separate property? Okay? So that's gonna be a difference when you're looking at intestacy rules. You gotta characterize the property in order to figure out who gets it. Again, community property is gonna go to the spouse. Separate property might not, right? And even if the spouse has survived and it's community property and that spouse doesn't have kids, that spouse still isn't gonna get 50 or 100% of that asset. Let's say the deceased spouse had parents. Then my spouse is getting 50% of my separate property and my mom is gonna get 50% of my separate property. So the code favors bloodlines for separate property over spouses, okay? So a spouse is only gonna get 100% of separate property if there's literally no one else, okay? So again, remember that you gotta characterize the property if you see it in a will question. Obviously, you know, real versus personal property. Personal property is tangible, it's cash, it's CDs, it's your jewelry, it's your car, it's your furniture, it's your bank account. That's all personal property. Real property is attached to land, Blackacre, right? All right, so now we have probate transfers and non-probate transfers. What's a probate transfer?
Intestate.
Yeah, it's gonna be intestacy. It could be also testate, right? You could have a will and still go through probate. What's a non-probate transfer?
Basically, it's transferred before you die.
Not necessarily.
Well, trusts.
That could be a trust, yeah.
Or like an insurance, you could like name somebody the beneficiary of your,
On anything.
yeah,
Oh yeah, something with a named beneficiary on it.
anything with
That
that.
transfers at that.
Yeah. So what needs to go through probate? Only things that can't be transferred without court intervention. Anything that's in joint tenancy, as we know in property law, goes automatically to the joint tenant, right? Beneficiary designation. Beneficiary designations trump probate actions. Those beneficiary designations are gonna go to those beneficiaries, it's gonna be outside of probate. Also transfer on death deeds, right? That's a way of a beneficiary designation on real property. That's gonna go outside of probate. None of those are probate transfers. So it doesn't matter what the laws of intestacy are, right? It doesn't necessarily matter what your beneficiaries are under your will. They're all outside, okay? Contracts too. Let's say, you know, you had some sort of contract, some promissory note that had a succession plan built into the promissory note. You know, when I die, it's going to my best friend Joe. Okay, well, now I'm dead, best friend Joe's gonna collect on that promissory note, okay? Life insurance, pay on death, all those things that you don't need to go to court to transfer them. You only need to go to court to transfer something if it is in fact without a beneficiary, right? It's not in a trust, there's nobody listed, and there's nobody else who can possibly get it by contract law or any other mechanism, okay? So why do we think that people don't have wills.
They don't think they have anything to give.
They don't want to think about it. They put it off.
Yeah. You know, over 50% of Americans don't have any estate plan. Some of those estate plans are just a simple power of attorney. Some of them just have an advanced healthcare. A lot of people don't have a will. Many, many, many people don't have a will. And even fewer people have a trust. Okay? So your questions on the bar are gonna be people who don't have any planning. Or they have planning and it's poor, right? There's an error in the planning somehow, or it doesn't work for whatever reason. Okay? So, you know, that's interesting, but mostly we don't care for the bar. Again, surviving spouse, this is gonna come up in the context of community property versus separate property. If you have a surviving spouse and there's an intestacy question, there's not gonna be any planning, there's not gonna be a will, there's not gonna be a trust, and you gotta figure out what property, what's the characteristics of this property, and then you can figure out where it's going. But that's, you know, number one, is there a will? Number two, what type of property is this? Okay. Yeah, we know we're a community property jurisdiction, so we don't have to worry about that. Again, per stirpes versus per capita. Per stirpes is, you know, we're gonna go down and we're gonna give it to the level of generation. Per capita is we're gonna be fair about it. So in our Aretha Franklin, if the grandchildren are inheriting, every grandchild inherits equally, versus that grandchild inherits just that parent's interest. That's probably the easiest way to think about it, right? Most of them are gonna be, it's gonna say it in your question. It'll say per stirpes or it'll say per capita with right representation, because otherwise you just gotta guess.
How come? Let's see. Okay, yeah. So how come, for example, 2-5, Edward, Fran, and George get different amounts, even though it's per capita with representation, if they're on the same generational line?
Because Charles and Doris lived. They were the first one that were alive.
Oh, so as long as the first line it has somebody living in it,
yep,
then it doesn't get split evenly between the next generational line? Oh.
You go to the living line.
Okay.
Now, if Charles and Doris had died, what would it have been?
Then it would be a third, and third.
Correct. Because Charles didn't have kids, Doris didn't have kids, and the only surviving generation is grandchildren.
Oh.
Okay. Now you're gonna get something a little bit more complicated. You're gonna get a grandchild who then had kids, and then they're probably gonna throw things in there like you don't care. You know, a surviving child had a kid, but who cares because it's going to a surviving child. Remember, you go to the line that's alive. You don't go further than that. So under our Aretha Franklin, her 4 boys are alive. This is the actual real example. Her 4 boys are alive. They will all inherit equally. It doesn't matter if she has grandkids. We don't care. Okay? We go to the level that's alive.
And so is per capita with representation and then per capita at each generation different? Like as far as a different theory? Because, for example, 2.6, it says that like Charles and Doris get a quarter and a quarter, and then at the next generational line, it goes to 6 and 6 and 6.
Right.
Even.
So that's at each generation.
So is that just a different theory? So there's per capita with representation per capita at each generation, and then per stirpes?
And we use in California per capita with representation. So you're probably not even going to care about per capita.
So don't even care about per capita? Okay.
No, for the most part. Spouses, if I die, does my husband inherit from my mom's estate?
No.
No. My husband is not a lineal descendant. He may be an heir at law, but he's not a lineal descendant of mine for purposes of my mother's estate. Okay? Now, if my husband becomes my adopted son, then it might be a little different, right? But that's not the scenario that you're probably going to get. You're probably going to get, Joe has no children but has a predeceased or has a spouse.
But if you had children, your husband wouldn't get anything and your children would get it.
Well, if he's adopted, then you would share with your children.
Yeah, another part of that is kind of one of those interesting situations. So,
This is my brother thought.
Yeah, we also have, we have family law statutes too, that prohibit against, intersexual relations with family members. So that would probably also be problematic if you're gonna adopt your husband and then continue to have sexual relations with him, right? That may have some sort of statutory issue.
And some kind of other laws.
Yeah.
So we're not gonna adopt our spouses here. So yeah, we're just harping on collaterals versus lineal descendants. Collaterals, all those people further down on the line. Right? Lineal descendants are my issues. My issue is my children, my grandchildren, my grandchildren's children, my great-great-grandchildren, things like that. It goes down on the line. You probably want to check out the chart about intestacy heirs, but you're probably not going to get to the fourth, fifth cousin down here. You're probably going to get to maybe a niece or maybe a cousin, something like that. It'd be unlikely that the bar is going to give you issue of great-great-grandparents. Right? But if there's anything about, if you hear the word cousin, they're probably going to get it over the state. Right? Because again, we favor giving it to our family versus the state of California. It's very, very rare that we give it to the state of California. It's very rare that we actually issue it.
State of California gets it, what do they do? They auction it off? Or?
No, it goes into a common fund, and I actually think it goes into a unclaimed property account for a while, and it sits there for a fair amount of time, and then it'll go to a more formal setting where it goes to like a treasury department that still can be assessed by heirs if they come up, and then it's some very, very long time after that, years later, that it actually goes into a general fund that the state of California can actually use. And like I said, that doesn't happen that often. We're gonna find an heir. There's heirship companies out there for this purpose. You can hire a company that will go and search birth records, death records, etc., to find all of these heirs down the line, these collateral heirs all over the place. Because like I said, it's rare that we're not gonna have at least someone, somewhere, that didn't have a beneficiary, or excuse me, an heir.
Seems odd to me, because I worked at a bank, and we would escheat stuff to the state all
Well,
the
but
time.
you put it in unclaimed property. That's slightly different.
Yeah.
So unclaimed property is still a mechanism that beneficiaries can get. And that's because the banks don't have an internal mechanism for research.
Yeah.
They don't care.
Yeah.
All they say is, okay, it's been here vacant, it's been
It's been for
dormant.
7 years, okay, bye.
It's dormant for 7 years, I don't care. Off of our records, off of our books, we don't want the liability for it anymore. Now it's here. It's not escheating to the state, it's going to unclaimed property.
We call it escheat.
Right.
But yeah, no, I get it.
But yeah, so it's slightly different, okay? Because the state of California doesn't actually own that property yet, okay? All right. Any other questions about this intestacy?
The only thing that I really didn't understand was the whole canon law system. And do I need to understand that? Okay, because I got the civil law system where it still goes to the next closest relative.
Yeah, we don't have canon law.
Okay, but I was like, with the canon, it didn't make sense that it would go a third, and a third when they're on different generational lines.
That's a history lesson that's interesting but inappropriate for the bar.
Okay, cool.
Okay. So remember, just intestacy in California, we have an intestate statute. We have the ability to say, where is it going? If you don't have an estate plan, the state of California gives it to you. That's intestacy, right? Okay.
Awesome.
Anything else? No questions about Aretha Franklin?
I wish I was her kid, but
Well, and so.
Actually, no, they're probably gonna fight with each other over all that money, so.
And they are, and that's another sort of unfortunate thing about these estate plans that don't have a will, that don't have a trust, is that although the state of Michigan, I think that's where she is, Michigan is gonna say her intestate heirs are her 4 children, they're still gonna fight about it.
Sure, like.
There's a lot of
Well, how do
money,
you-
property and
$80
Well, and
million.
also there's like what are they, like,
royalties and stuff like that.
royalties, like, they'll have to keep paying out.
Yeah,
They're gonna have to set up a trust, basically.
yeah, trust for it to go into and then.
Yes and no. What they can do, I have a client, he was an actor, and he's dead, but he had interests and he has movie rights. So sometimes they pay out and they're, $5,000 a month, and sometimes they pay out and they're $200 a month. It just depends on how often that movie is shown, right? But what we're gonna do in his probate estate is we're gonna assign those royalty interests to his heirs. Now, he had no children, he had no spouse, so his heirs are
His parents.
his parents. They survived. So what you do with that situation is then I go to SAG, Screen Actors Guild Board, and I say, this is my order from probate. All of the royalties that you are governing and you are managing, you don't now pay him to the estate, you pay them to these 2 people. Right? So they don't have to set up a trust if they don't want to. Now they should, because what happens when they die, right? They should assign them to a trust, but they could just easily go. So Aretha Franklin can say, all right, respect, the royalties on that song are gonna be split 4 ways for the rest of eternity. Okay, they can do that.
Oh, they can do that? Oh, okay. Yeah, I figured it would like have to go to one person or into one account and everybody can do whatever they want with money.
But it's gonna get really fuzzy once there's like,
Grandkids.
great grandchildren. Like, I mean, that's not gonna be around in 100 years, I mean.
Aretha doesn't care. She's 69.
Yeah, right. Now, how much is Aretha's estate gonna pay in estate taxes?
A lot.
So she's gonna pay anything over 11.2 million. After all these administrative expenses. Guess what, attorney's fees are administrative expenses. So there's gonna be a whole lot of attorney's fees, because all these 4 boys are probably gonna fight over who gets what.
Yeah.
Right, so there's gonna be a couple $100,000 in attorney's fees at a minimum, right? All of those are deducted as expenses for the estate tax return. Now, $200,000 out of an $80 million estate, whoop-de-doo, right? But they're gonna pay a lot of money in estate taxes. Had she set something up that said, to each of my boys, an equal share of my exemption amount, right? And the rest goes to, I don't know, the, Soul Music Hall of Fame or whatever, great, she would pay nothing in estate taxes.
They get a lot less.
They would. They would. That's true. But there wouldn't be any estate taxes owed. Okay. So you can plan around estate taxes, but you have to do it in some mechanism. Since she didn't have a spouse, you can't use a marital deduction. And you don't get any deductions for giving it to your children.
Oh, do they have deductions like in bankruptcy and stuff like that, where if you're giving it to this person, there's deduction, or is it only your spouse?
Only to your spouse. For estate taxes, you have the marital deduction, and that's the deduction that you care most about, because that allows you to give any amount over to your spouse.
So if you can give it to a charity, can you give it to like a business?
Only if it's a qualified 501c3.
Okay.
Oh, you can't just like,
To allow that to be a
non-taxable gift.
non-taxable gift, yeah.
Yeah, but you can give it to anybody,
give
they
it
just
to
have to pay
whoever you
taxes on it.
She could have even given it to her dog. Right?
Why not?
The Helmsley case allowed that. In California, we've codified that. We allow pet trusts. Now, it has to be a reasonable amount. So you'd probably give 80 million for the benefit of her dog. But she probably could have set up a trust for 100,000, 200,000. She could have. She didn't. And she doesn't live here. She lives in Michigan. But be that as it may, you can do those things.
Better off being Mac Miller with just your parents.
Yeah. Another thing to remember too, in California, we don't have inheritance taxes. That's when you get something from an estate, you don't pay any taxes on it, right? You can just get it.
So you just get that okay.
If it's over the estate tax exemption, yes, don't pay estate taxes on it. Some states in the Midwest, for example, I think Indiana, Iowa, you pay an inheritance tax. So if I live in Iowa, I think it's Iowa. It's either or Indiana. There's a number of them that have them, but let's say I live in Iowa and I'm giving $200,000 to my best friend. We're not related. They might have to pay tax on that because that's called an inheritance tax. We don't have it in California. So if it comes up, you'll just say, no, there's no such thing, you don't pay for it. You know, but it might come up in, well, what is the inheritance tax consequence? Well, there isn't an inheritance tax consequence because there isn't one in California. There are some in other states. Other states also have their own estate tax. We don't. California doesn't have an estate tax and California doesn't have an inheritance tax. Places like Massachusetts, New York, they have their own estate tax. So not only are you going to pay a federal estate tax if your amount is over that threshold amount, you might also be paying a state estate tax. And those state estate taxes are generally a lot lower than the federal estate tax. So 10 years ago, Massachusetts had a federal estate tax that was at $1 million. The federal estate tax was at $2 million. So if you had that sweet spot at 1.5, you didn't pay the feds anything, but you still paid estate taxes to the state of Massachusetts. We don't have that. So if that comes up, what's the inheritance tax consequence for a California resident? What's the estate tax consequence for the California decedent? None, because we don't have those taxes in California. The only tax that you're going to possibly get when you die in California is going to be capital gains taxes, but that's going to become later, and an estate tax. And again, that doesn't get paid to California, it gets paid to the feds anyway.
And that's dependent on where you live, not where the person died, right?
Where the person died.
Oh,
That's
so if my parents live in New York and I live in California and they die and they leave me whenever they leave me,
they might
I have to pay the New York taxes even though I live in California?
Yeah, you may have to pay an estate tax in New York.
Mom and Dad need to move.
I'm pretty sure the estate tax now in New York is probably very high because they like to be sort of in concert with the federal tax. But now that the federal tax is so high, again, this is unprecedented territory. We've never had a federal estate tax this high before.
Sure, New York people though, they want their
Yeah,
money.
I mean they might, but the goal is California. We don't have it, right? So if you get it on the exam, you're not gonna be concerned with it. Boom, it's not a tax. They don't pay anything, right? They're only gonna be concerned with paying an estate tax at the federal level. Okay. Any other questions?
Right.
Yeah, it's a lot of fun.
It's a lot of information.
Yeah, it is. It's a very heavy bet, and unlike other forms of law, this is stuff that you're not going to have seen a lot. Most people don't talk about the provisions of a will or a trust. Most people have never even known how to pronounce perstrictus, right? So, unlike other things, contracts is a little bit more intuitive. Criminal law is very intuitive. Obviously, you don't kill someone. Great. That's pretty self-explanatory. But in wills and trusts, you're going to have terms that you've never seen before, and you're probably not going to ever see again. If you don't practice in this area, you're going to see it on the bar, and then you're not, like I said at the beginning, you're not going to think about it for 20 years until you got to draft up your own documents. So I get it. I get that it's heavy. I get that there's a lot that just is sort of over your head. But unlike other forms of law too, it's pretty clear as what there's not a whole lot of wiggle room, right? You're either an heir or you're not. I'm either married, I'm not. It's either community property or it's not, okay? So that's one comforting thing about this form is that it's pretty, when you get the rules and when you get the foundation of the principles, you can pretty much make a decision and it's going to be easier to make that decision than in other things like property law or common law, for instance. Yeah, exactly. Okay. All right. So the one thing aside from the required stuff for next week, I will be here next week, is the Slayer statute. So under my scenario, my brother killed my decedent. My brother had a son. Does my brother's son, my nephew, inherit from my estate? Okay. So bring me the answer and bring me how you got it.
Wait.
Okay? All right, here we go, Dylan.
I guess I'll go down.
if it does go with the kid, someone could just wipe out their entire family in the interest of it.
Yeah, exactly.
Don't give up my plans.
Well, it's kind of a punishment too, though, right? I mean, you maybe should be punished if you killed somebody.
Yeah. You should definitely be punished if you kill
Yeah.
somebody.
But maybe you should be punished by not allowing anybody in your realm to
Yeah.
wear it. Or maybe not, maybe because it's not the nephew's fault.
Interesting question.
And then we can make advice as to who can kill who.
Take a draft out there, why not?
You can kill these people, but not these people.
Let's see.
Right?
Okay,